Good morning everyone and welcome to our February webinar. This month we'll be listening to Jamie Jones, our Head of Service. He's going to talk us through what GT Maritime's GDPR approach will be and what GDPR means to us. We've had some really good webinars recently and we've uploaded them all onto the partner portal. We'd love you to join that if you haven't already. There is a link in the prior registration email if you want to click on that. Otherwise it's partners.gtmaritime.com. Okay, I think everyone's just joined, so without further ado, Jamie Jones.
Thanks, David, and welcome to everybody on this GDPR and GT Maritime webinar. During this session, we'll take a brief tour of GDPR, look at how it might affect us, and how GT Maritime are preparing for the implementation. So what is GDPR? GDPR is a new European General Data Protection Regulation. The key word in this phrase is regulation. As a regulation of the European Union, it will come into force without ratification or implementation by member states. It replaces existing data protection laws within European countries and the existing Data Protection Directive, and is enforceable from the 25th of May 2018. One of the key focuses of the regulation is to allow individuals better control of their data through access to organisations who hold their data and specific regulations around consent. So the GDPR scope is really interesting for the maritime industry given its global nature. The regulation is intended to establish one single set of rules across Europe. However, this doesn't just affect data within the EU. Organisations outside the EU are subject to the jurisdiction of the European regulators just by collecting data concerning an EU resident. One other interesting part of the GDPR scope is whether the UK's exit from the European Union will affect the implementation of this within the UK. The UK government have clarified that they are absolutely committed to implementing GDPR along with stringent national laws to complement it as well. So one of the key areas, as we mentioned in an earlier slide, is access and control of personal data. What is personal data? From the regulation, the personal data is defined as any information related to a person who can be identified directly or indirectly. This might include name, identification numbers, or any other of the listed aspects that may identify a person. In many cases, this includes online identifiers such as IP addresses, cookies, and so forth. These will not be regarded as personal data if they can be linked back to the data subject. One of the interesting parts of this is business-to-business data. In the early phases of the GDPR regulations being published, it was thought that business-to-business data wouldn't be included in the scope of this. However, it's now becoming clear that that actually is the case, as, for example, my email address, jamie.jones@gtmaritime.com, clearly identifies me as an individual working for GT Maritime. GDPR applies to both the controller and the processors of data, much in the same way that existing data protection laws have. However, GDPR brings the same level of responsibility to processors as controllers, and controller-processor relationships must be documented and managed within contracts. So looking at controllers and processors further, within GT Maritime, we act as a controller, both a controller and a processor. GT Maritime office data, so details of organisations that we work with, our staff records, finance records, tax records. We are clearly the data controller. And in the data that we actually process on behalf of our customers, we are acting as the data processor, contracted by our customers to process their email. One of the big parts of the GDPR regulation and a major motivating factor behind some of the GDPR work that's going on, not just in GT Maritime, but throughout European organisations, is the change in fine structures for data breaches. In the UK, the current maximum fine for a data protection breach is £500,000. The maximum fine delivered to date in the UK has been £400,000 for a significant breach. So everyone talks about how there is a €20 million fine, but this is actually split into two areas. Firstly, regulators will have the authority to issue penalties equal to €10 million or 2% of an entity's global gross revenue for violations of record keeping, security, breach notification and privacy impact assessment obligations. Some of the key parts of that are global gross revenue, so that there is no hiding of revenue in these fines. The second part of the fine structure is for serious violations of obligations related to legal justification for processing, including consent, data subject rights and cross-border data transfers. These penalties are in the order of €20 million or 4% of the entity's global gross revenue. I just wanted to come on to a couple of examples of fines that we may have seen. The first of which is a UK telecoms company with a turnover of £1.8 billion. On the basis that their gross revenue exceeds the €20 million fine, the example here is that it could be as much as £73 million in terms of a fine, and based on the principle of 4/5 of the maximum, given that previous fines have only ever been up to that level, that might speculatively be a £58 million fine. The other example that we have is a supermarket company with a turnover of approximately £56 billion. They were also fined the maximum of £400,000 under the previous regime. And again, using the 4% calculation, given their revenues are significantly in excess of what the €20 million fine would cover, the fine for that organisation, could potentially be somewhere in the region of £2.2 billion. Or, again, bringing it back to the 4/5 principle, that could be £1.7 billion of fines, which I'm sure you'll agree is fairly hefty. The next section that we want to cover is what are the lawful bases for processing data. There are 6 in all. So, first one is the data subject is given the consent to processing his or her personal data for specific purposes. Specific purposes is a really important phrase, which means in this context that if a customer or lead or prospect or any person for that matter provides contact details for receiving a newsletter, that can't then be used for other purposes. Each specific purpose must be consented to. So the second basis is processing is necessary for the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering into a contract. Third part, processing is necessary for compliance with a legal obligation. Fourth one, processing is necessary in order to protect the vital interests of the data subject or any natural or another natural person. Processing is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. And 6, processing is necessary for the purposes of legitimate interest pursued by the controller or by a third party. For the most part, GT's processing falls into a couple of categories. For our marketing operation, number one is clearly the key basis. So one of the things we're currently working on is ensuring that we have the right levels of consent for all the marketing activity that we carry out, and that all of our privacy policies and so forth are all up to date and in line with the requirements of GDPR. The vast majority of data processed by GT Maritime is actually focused around the email processing for customers. We have clear rules within our business on who can access this data and how it might be used, specifically only for the support of that process. We also publish our data retention policy for this information. And this is actually covered quite clearly under Section 2. We have contracts in place with all of our customers to process that information. We also process data under items 3 and 6. However, these generally cover internal operations of GT, such as HR and finance. We would never process external data under legitimate interest, as we're not the controller for the most part. So, we'd just like to move on to a scenario now that prompts some interesting questions really around how GDPR will affect us. I'm not saying we have all the answers here, but it does provoke some interesting questions. So the scenario is: a European flagged vessel with EU crew members enters United States waters and is required to submit a notification of arrival and departure form to the Coast Guard. So this requires information about the crew members, including full name, date of birth, nationality, gender, passport and visa details, contact details, etc. All absolute classic information that falls under the scope of GDPR. The questions it prompts are, what consent is required by the crew to submit this to the US Coast Guard? Is the notification being made directly to the Coast Guard or through a third party? If it's through a third party involved in processing that data, what arrangements are in place for the security and other compliance requirements of that data? Is it suitably encrypted, suitably protected, etc.? And finally, what are the obligations of the US Coast Guard to comply with the GDPR in handling that data of EU citizens? So moving on to what GT Maritime have been doing. Over the last 12 months, we've been auditing what data we hold and how we handle it. Assessments have been taking place on the basis of what that data is held for, whether the data is subject to the appropriate measures of detection, and how that data is being used. Updates to our software ensure users have the ability to control how long data is stored for in our archives. For the most part, we're in good shape. We're tightening up our consent processes to be compliant, along with finalisations of policies and processes to ensure ongoing compliance after the enforcement date of the 25th of May. Breaches and notifications is the next section. So what is a breach? According to the regulation, a personal data breach is a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorised disclosure of, or access to personal data transmitted, stored or otherwise processed. So what are the obligations around this? Data controllers must notify appropriate supervisory authorities, usually national information commissioners, without undue delay and, where feasible, not later than 72 hours after having become aware of it. If notification is not made within the 72-hour time frame, the controller must provide reasoned justification for the delay. Reasoned justification isn't quite clear in the regulations at present. However, it's thought that there's quite a high bar going to be set for what is reasoned justification. Importantly, when a data processor experiences a personal data breach, it must notify the controller of that breach. Should the controller determine that the personal data breach is likely to result in a high risk to the rights and freedoms of individuals, it must also communicate information regarding the data breach to the affected data subjects, which is a strengthening of that of existing directives. There are some exceptions here. Notice is not required if the personal data breach is unlikely to result in the risk of the rights and freedoms of individuals. So, moving on to the next section, which is about data protection officers. The regulation requires that organisations have expert knowledge of data protection law and practices, the level of which should be determined in particular according to the data processing operations carried out and the protection required for the personal data processed by the controller or the processor. Apologies, that was a direct quote from the regulation. The data protection officer's tasks are also delineated in the regulation to include informing and advising controller or processor and its employees of their obligations to comply with GDPR and other data protection laws, monitoring and compliance, training and advising with regard to data protection impact assessments. Within GT, we've appointed our very own data protection officer, and that's Kelly Powell, who's been with the business for quite some time in the role of HR manager, and this is an addition to her role. We have a dedicated email address for all data protection correspondence, and that is dpo@gtmaritime.com. Moving on to data subject access requests. Individuals will now have more information on how their data is processed, and this information should be available in a clear and understandable way. Requests must be executed without undue delay, and at the latest within 1 month of the receipt of the request. Within GT Maritime, we would request that any subject access requests be made to dpo@gtmaritime.com, although in accordance with the regulations, any request to any part of GT Maritime will have that request serviced. Finally, as we look to wrap up this session, we just thought we'd kind of pop up a few comments that we've seen kind of floating around the internet around GDPR. Have you heard any of them? So, consent is going to be so hard to get. I'm just going to use the legitimate interest basis for lawful processing. Please don't use that as a serious way forward. The test for legitimate interest is going to be pretty tough. So please look at kind of providing the right levels of consent to use information and process data. The next one, GDPR doesn't apply to me. I think it's pretty clear from the scope of the regulations that anybody who processes data in any way, GDPR will probably apply to. Whether that's holding customer data or processing internal information. Perhaps a UK specific one, but Brexit means I can just ignore it. Well, as we've kind of said earlier, Brexit has no impact on the implementation of GDPR. The UK will still be a member of the European Union at the implementation date, and as we've said earlier, the UK government have committed to the implementation of the GDPR. One issue we've touched on earlier as well, I'm just business to business, so I don't need to worry about GDPR. All the guidance that we can see at the moment is that that's just simply not true. As we said earlier, any information that can link back to an individual data subject is included, and therefore quite often business to business data will be part of that. Legitimate interest applies to everything, right? We've got legitimate interest in everything. Well, yeah, but as we've mentioned before, the bar's set quite high for determining what legitimate interest is. So, we really need to kind of get to the right basis for processing that data. Here's quite an interesting one for data purchased for mailing lists and so on and so forth. I bought the data in good faith, so I'm in the clear. Not sure quite how well that one would go down. I suspect not very well at all. I don't have a record of consent, so I'll email everyone to get them to opt in. Again, I think that perhaps goes against the spirit of the regulations. I'll think about it next year. That's quite an interesting one. I think for many organisations, GDPR has been a quite a significant piece of work for the last couple of years, and leaving it will just cause problems, because it's not just about an implementation; it's about ongoing compliance. GDPR is the same as the Data Protection Act. I ignored that, so I'll just ignore this. Well, that's quite an interesting take on the world. I think one of the things that we've highlighted in this session is that the fines structure for GDPR are significantly more hefty than any existing data protection regulation based on national law. While it might be tempting to ignore, I suspect the risk of a significant fine will kind of outweigh any benefit there. And finally, GDPR starts on the 25th of May. Well, that's the enforcement date. GDPR has been around for a good 2 years now, and one thing's for certain is after the 25th of May, it will be an ongoing compliance requirement for all organisations. So I hope that's been of interest to you. Please feel free to ask any questions during this time, and we'll do our best to answer them. And thanks very much for taking part and listening. Thanks very much.
Brilliant. Thanks, Jamie. Some really interesting points there. And if you've got any questions, don't forget to just pop them into the questions box, and we'll be on hand here to answer them anytime. Also, this webinar, along with the others, will be uploaded onto our partner portal, which I mentioned at the beginning. Again, that URL is partners.gtmaritime.com. So feel free to register for that. And there's also a lot of sales material and a great knowledge base as well for any questions that you may have. So we'll be on hand here, ready to answer your questions, and we'll stay on the line for a little while. Thanks again, everyone, and thanks again, Jamie.